Good morning, good afternoon, good evening to everyone. It's a pleasure for me on behalf of the International Association of Youth and Family Judges and Magistrates to welcome you to this webinar, the first one of a series addressing contemporary issues on justice and children's rights. My name is Eduardo Melo. I'm judge in Brazil, the editor-in-chief of the Chronicle, our association's journal, and I'm coordinating this webinar's program. Since AIMJF's foundation in 1928, this association took part in many of the most important moments of children's rights history at the international level. Today, with members in more than 60 countries, organizing world congresses every 4 years, the last one in Paris at UNESCO's house in 2018, we are proud to offer to our members and to a larger community in the world a variety of initiatives aiming to improve the justice system and children's rights. These activities, focusing always in comparative approaches, range from study tours every semester in one country to researches, both on jurisprudence and on the organization of the justice system, the elaboration of guidelines, a bi-monthly newsletter, and our journal, the Chronicle, with theoretical and practical analysis of the most important subjects that judges, magistrates, and legal professionals have to deal with when working with children's rights. We believe that international dialogue has always played a major role in the improvement of legal systems regarding children's rights. We'll be very pleased to have you as our member joining our association. Please visit our website for further information. Now, with this monthly webinar program, we'll have one more opportunity to be close to you, inviting prominent members, academicians, and legal professionals from different countries and legal systems to discuss with you contemporary issues on justice and children's rights. Today, we'll discuss the UN Committee on the Rights of the Child's General Comment 24 on children's rights in juvenile justice, its principles, the requirement of a comprehensive policy, and the organization of the juvenile justice. The Committee on the Rights of the Child has the privilege of having a global perspective of the most important issues of this subject, and its general comments are always a very good guideline for us in the field to reflect about our challenges and to seek for improvements. To discuss this important topic, we thought it would be important to have three different but complementary perspectives. One of the committee itself, another one related to training, and finally one on the implementation of the general comments. Therefore, I'm very pleased to introduce to you the speakers of this webinar, Professor Skelton from the University of Pretoria in South Africa, member of the UN Committee on the Rights of the Child, Judge Jorge Jiménez, judge in Spain, director of the Spanish Judicial School and of the Ibero-American Network of Judicial Schools, and Justice Ciminelli from the Supreme Court of Bangladesh, the Appellate Division. We'll have their presentations, 30 minutes for Professor Skelton, and then 20 minutes for Judge Jorge Jiménez and Justice Imman. And then we'll have the opportunity for a dialogue and to answer questions raised by you. You may write your questions on the chat, and I'll do the mediation and bring in these questions to our speakers. We begin with Professor Skelton, who is a professor of law at the University of Pretoria in South Africa, where she holds the UNESCO Chair in Education Law in Africa. She's also the director of the Center for Child Law, which promotes children's rights in South Africa through advocacy, law reform, research, and litigation. And she's a member of the UN Committee on the Rights of the Child. Professor Skelton, you have the floor.
Thank you very much for those kind words of introduction, and greetings to everyone, wherever you are listening and watching this webinar. COVID-19 has opened up the world for cross-disciplinary and cross-country comparative work, and this is one of the benefits that I think we are gaining from it. Even though I think everyone is also getting quite tired of having so many webinars. So I hope that we will keep you engaged and that this webinar will not become dull. So, General Comment 24. What are the main features of it that I should draw to your attention? Well, let me start by saying a little bit about its genesis. Why did the committee decide to come up with actually its second general comment on this topic. I think the committee has always been very committed to its monitoring of Articles 37 and 40. We see going back in the history of the committee that the committee has always asked a lot of questions about this in states party reviews, and has always been very concerned, particularly about children deprived of their liberty. I think another reason why the committee decided that general comment number 10, which was its first general comment on these issues, needed to have a be revised, which is what the original plan was, just to revise general comment number 10, partly because of some of the new research that has been coming out, that we know so much more now about the adolescent brain, about childhood and brain development, and what that might mean for issues such as the minimum age of criminal responsibility. And I'll come back to that issue later. That was certainly one of the factors at play that led to the revision. But as the committee started working on the document, it became apparent that there were actually a lot of new things to say. And so the revision grew into a completely new general comment. And that's why it has a new number 24, and it actually completely replaces general comment number 10. Now, I think it's important as well to say that the vision of the committee when it comes to children in the criminal justice system is that we obviously want to see, as the convention itself imagines, a child who in such a system, that child's dignity and worth is valued, the child is dealt with in a rights compliant way, and there is work put into a reintegration of that child back into society. And of course that we do want children that learn through these processes to respect the rights of others as well. And I think it's true to say that in the 30 years of the convention and the recommendations given to states, we have seen a lot of improvements in justice systems around the world in the way that they deal with children. And what we are also seeing is that the benefits of a rights compliant system actually is felt by society as a whole. There is some very interesting research emanating particularly from researchers in the Netherlands who have been looking at how the numbers of children coming into the criminal justice system have been declining over the last 2 decades, in particular the last decade. These are mostly developed country statistics that they're looking at, but there's certainly some evidence from South Africa now, where I live and work, that are showing similar patterns, that actually we're seeing that with a rights compliant system, you have fewer children coming back to the system, and even first offenders rates are going down. Now, we don't know all the reasons for this, but I think that we can say that some of the work that's going into prevention and into early intervention and into reintegration is bearing some fruit. I think it's also important to look at the language that we're using. So the general comment number 10 was called the general comment on the rights of children in juvenile justice systems, and any English speakers will have noticed that general comment number 24 speaks about the rights of children in child justice systems. And it was a very interesting debate in the committee about whether we needed to have this wording change. But many of the states that commented on the draft general comment, as well as experts and NGOs, felt that it was time to move away from the use of the word juvenile. Now, it is perhaps an obsession of English speakers, because I think that French speakers don't seem to worry about this so much. And Spanish speakers use a different term anyway, so this is not really something that they are so worried about. But English speakers are kind of moving away internationally. We've seen a lot more use of the word youth justice. We've seen a lot more use of the words child justice. And so in a sense, this change in the title of the general comment does, I think, signal the fact that we want states parties to remember that the people that they're dealing with in these systems are in fact children in terms of the Convention on the Rights of the Child. Now, I know there are a lot of debates about the fact that some young people don't want to be called children, et cetera, et cetera. I get that. But at the same time, I think when it comes to states parties' obligations, it's quite important that they don't start saying, well, maybe children below the age of 10 are children. But when it comes to these teenagers that commit crime, we don't want to call them that. So as I said, it seems to be something that has more resonance with English speakers than other languages, but it was an interesting debate that we had in the committee. So the revision also looks at a few new areas. As I've mentioned, we do pay more attention to the idea of adolescent brains and what that means for things like criminal responsibility. But we've also included two completely new areas which were not included in General Comment number 10. The first of those is the children recruited and used by non-state armed groups, and including those designated as terrorist groups. So previously this wasn't in the General Comment, now it is in General Comment number 10, although it is dealt with quite briefly. And there is also a section on children who are coming into customary law or indigenous systems of justice, and how that should be approached within a child rights compliant manner. The General Comment looks at the core elements of a comprehensive justice policy and starts quite predictably with the idea of the importance of prevention. And here the committee urges states parties to consider comparative and international research on prevention measures to avoid children coming into the criminal justice system, the primary prevention measures, and also really points to the importance of states doing their own research on what causes children to come into the criminal justice system and what can be done to try to prevent the flow of children into the criminal justice system, and being more receptive to the fact that things are changing. And as I've said, actually we're seeing a drop in the rate of children coming to the criminal justice system in many countries. So states need to be responsive to that. They need to be aware of it, and they need to adjust their policies and their laws for these new realities. Another thing that is flagged there is status offences, and it's given a little bit more prominence than it was in General Comment number 10. So these status offences that are things that are only crimes if the person doing them is a child. And the old common ones that we used to see was children who were running away, or children who were going truant, not attending school. But I think there are also some new status offences that we see emerging as well, such as the criminalisation of adults who engage in consensual sex, but because of tough new laws are getting caught into the web of criminalisation. And so the General Comment, advises states to be careful about this and to make sure that children are not brought into the criminal justice system due to status offences, including these kind of new generation status offences. Diversion is also obviously very important and is flagged as a major intervention. That is at least a secondary prevention technique that can keep children away from the harmful effects of the system. We like to see this happening from as early as possible, and the committee makes a distinction between diversion at the pre-trial stage, which we are very much in favour of, and the use of measures once the child's already come into the system to keep them away from custodial sentencing, for example. So I'll come back to non-custodial sentencing, but just to make it clear that the committee places great emphasis on the idea that diversion should be available at all stages of the system, but starting from the earliest possible moment to cause children to have the least possible interaction with the criminal justice system. Now, coming to that thorny difficulty of the minimum age of criminal responsibility. You know, the convention itself doesn't give any particular guidance on this. It simply says that states should set a minimum age that should not be too low. And obviously this was not providing sufficient guidance. So the committee, when it drafted general comment number 10, decided to take the plunge and recommend a minimum age. Now, actually, what the committee said then was fairly clear, but it nevertheless gave rise to a lot of confusion and some negative consequences, which I will outline in a moment. But what general comment number 10 had said was that it can be concluded that a minimum age of criminal responsibility below the age of 12 years is considered by the committee to be not to be internationally acceptable. States parties are encouraged to increase their lower minimum age to the age of 12 years as an absolute minimum age and to continue to increase it to a higher age level. So what I've just read you now comes from the old general comment, not the new one. Now, the jury is still out on whether it was a good idea for the Committee on the Rights of the Child to attempt to do that, because what some states then decided was, oh, so if we have a higher minimum age than 12, this means we can now bring it down. And in fact, what happened was that we saw several countries, including Denmark, Georgia, Hungary for serious cases, and Panama, lowering the minimum age of criminal responsibility. When these states came back up for review, the committee took this issue up with those states and said, but why did you do this? This isn't what was intended at all. And some of them have changed. Denmark, for example, have changed their minimum age back to 15. But right now, there are a number of states in the world that are trying to lower their minimum age, including the Philippines, Indonesia, and most recently, China. So we can see then that there was uncertainty created as a result of this. And so general comment number 24, the committee decided to be absolutely clear what its position is. And it's important to note that actually over 50 states parties have raised their minimum age since the Convention on the Rights of the Child came into operation. So the majority of states are going in the right direction and did understand that the idea was to raise the minimum age. And the most common minimum age of criminal responsibility internationally now is 14. And the committee goes on to say the following in general comment 24. Documented evidence in the fields of child development and neuroscience indicates that maturity and the capacity for abstract reasoning is still evolving in children aged 12 to 13 years due to the fact that their frontal cortex is still developing. Therefore, they are unlikely to understand the impact of their actions or to comprehend criminal proceedings. They are also affected by their entry into adolescence. As the committee noted in its general comment number 20 on the rights of children during adolescence, adolescence is a unique defining stage of human development characterized by rapid brain development, and this affects risk-taking, certain kinds of decision-making, and the ability to control impulses. States parties are encouraged to take note of these recent scientific findings and to increase their minimum age accordingly to at least 14 years of age. Moreover, the developmental and neuroscience evidence indicates that adolescent brains continue to mature even beyond the teenage years, affecting certain kinds of decision making. Therefore, the committee commends states parties that have higher minimum ages, for instance, 15 or 16 years of age, and urges states parties not to reduce the minimum age of criminal responsibility under any circumstances. So I think the committee makes it pretty clear now what their position is and gives a stronger rationale based on developmental knowledge and developing neuroscience. And I think it's also important, the committee does flag the fact that although the setting of a minimum age of criminal responsibility is very important, the committee is also still concerned and interested about what happens to the children below that age. So when states parties report to us, we will be asking those kinds of questions as well. So, right, you set your minimum age of criminal responsibility there, but what happens to those younger children? I think what's also interesting in General Comment 24 is that the committee touches on the issue of the upper age as well, and says that the upper age limit should be 18 and encourages all states to ensure that the child justice system is extended up to that level for all offences and not allow any referrals out of the system at a younger age based on a particular offence category, for example. And of course, there are some states that are taking measures that go beyond the age of 18 up to the age of 21, and the committee acknowledges that these are positive developments. Moving on then from the minimum age of criminal responsibility, the committee also looks at the guarantees for a fair trial here. And I think something that's very strong in General Comment number 24 is the importance of children's rights from the moment of arrest, which wasn't a very strong theme in General Comment number 10, but now there's a lot more emphasis on what should be happening in that early stage, the moment of contact with the system, including stopping and warning. What should happen to children when they're in the custody of police or other law enforcement agencies during transfers to and from the police station and courts, and during questioning and searches and the taking of evidentiary samples. So proper record keeping and tracking is also required to ensure children's safety. And these are all new features in General Comment 24. Also, during the trial phase and even earlier, starting from as early as possible, legal representation and the importance of it. The committee expresses the concern that many children face criminal charges and are even deprived of their liberty without the benefit of legal representation. And the committee notes that Article 14.3d of the International Covenant on Civil and Political Rights, which applies to everyone, confers the right to legal representation as a minimum guarantee for all persons, and that this should apply equally to children as well. So the committee says, in the light of the above, the committee is concerned that children are provided less protection than international law guarantees for adults. The committee recommends that states provide effective legal representation free of charge for all children who are facing criminal charges before judicial, administrative, or other public authorities. And child justice systems should not permit children to waive legal representation unless the decision to waive is made voluntarily and under impartial judicial supervision. This too is a new feature in the general comment. Non-publication of the identity of child offenders is also strengthened, and the committee expresses a view that this should continue even if children turn 18 during the proceedings. In fact, the committee's view is that there should be lifelong protection from the publication of the identity of a person who committed the crime when he or she was a child. I'm moving on now to non-custodial measures. And the committee strengthens the idea that non-custodial measures should be the default position. That should be what happens in the majority of cases. And the committee has actually moved away in its concluding observations from speaking about alternative sentencing measures. Because if you talk about alternative sentencing measures, it sounds as though custody or prison is the main sentencing measure, and non-custodial is the alternative. So we don't want that to be the case. So we now are being very careful about only using the terminology non-custodial measures, which should be in the majority of cases. And then when it comes to custodial measures, the committee had a very long deliberation about whether we should, for the first time, because we hadn't done this before, set a maximum duration of a sentence. In other words, how long, should there be a rule that stops courts sentencing children for longer than so many years? Some committee members were in favor of doing this, but we soon found that when we started debating it in the committee, there was quite a wide range of different views about what that maximum would be and where one would set it. And for some people, one person's maximum sounds incredibly long, and others would say, oh, that's never going to fly in my country, and so on. And we put an idea into, well, we raised this in an early draft, and we got feedback from states parties that kind of discouraged us from putting that in. So we've basically left it up to states parties, but we have said states parties should set a maximum length of period of time. But obviously that would be then decided upon in the legal context and by the legislatures in the countries concerned, rather than the committee setting a kind of international maximum, which we found was probably not workable. But we do also still stress the idea that detention as a measure of last resort really needs much more emphasis when it comes to sentencing, that the best interests of the child must be considered as part of sentencing, although we recognize, obviously, in serious offenses, that there are other factors to weigh in the balance as well. The committee also is absolutely clear that minimum sentences, mandatory minimum sentences, are not appropriate for child offenders because this sets a minimum and it doesn't allow the proper consideration of the principle of deprivation of liberty as a measure of last resort. Because if you have a minimum sentence, that is your first resort. And even if you're able to depart from it, like some systems in South Africa, we had a law like this that allowed one to depart from it. But our constitutional court here ruled that that was unconstitutional because it didn't allow you to really start with a clean slate. Start with 0 and work your way forward. Don't start with 20 years and work your way backward. And so the committee actually uses this terminology of the importance of sentencing of child offenders starting with a clean slate and working forward. And this is the only way that we can really make sure that the important principle of deprivation of liberty is a measure of last resort. And don't forget, for the shortest possible period of time, for the shortest appropriate period of time, is also hugely important. And the general comment stresses that as well. The general comment also talks about the importance of other impermissible sanctions, other sanctions that we are discouraging states from using. So, as you know, the convention itself prohibits the death penalty and also life imprisonment without parole. But the general comment goes further and says that states parties are urged to get rid of any forms of life imprisonment, whether with or without parole, and that indeterminate sentences, these kinds of sentences where a child is sentenced at the president's pleasure for an unknown period of time, this is also, according to general comment, not a permissible form of sentence. And the committee notes the 2015 report of the Special Rapporteur on Torture, which found that life imprisonment and lengthy sentences are grossly disproportionate and therefore cruel, inhuman, or degrading when imposed on a child. Of course, when it comes to the death penalty, the committee calls on those few states that still have not yet abolished the imposition of the death penalty to do so without delay, and that any existing death sentences must be commuted. Still on the theme of deprivation of liberty, the committee tries to hone in on arrest as the starting point for when deprivation of liberty must, that principle must kick in. So we mustn't just think about this at sentencing, we must think about it from the moment of arrest. And of course, in the pre-trial phase, because so many of the children who are deprived of their liberty in the world are deprived whilst they are awaiting their trials. And this is such a travesty of justice. It's come through clearly in the global study on children deprived of their liberty, that this is where the majority of children are deprived of their liberty. And these are children who have not yet been found guilty. And so it's very important that states must focus on this area. The general comment says that states parties should also provide regular opportunities to permit early release from custody, including police custody, into the care of parents or other appropriate adults. And there should be a discretion to release with or without conditions. We shouldn't have to always think about the payment of bail. When we're talking about children, they don't have money, and it's inappropriate to be asking parents to pay bail. It's simply about whether or not they can go home, and if there is a concern that they might that they may not show up for their trials, then you can build in other conditions such as regular reporting at the probation office or the police station and so on. But there are many ways. Of course, this was drafted without thinking about a public health emergency that we've seen now. And I think all of us must be getting very worried about the fact that there are children still in custody around the world awaiting trial, and that trials are being delayed more and more all the time because of the fact that courts are not running as smoothly as usual and so on. So I really think this is a moving target, and we need to be urging states to pass the necessary laws, and of course urging all presiding officers and courts to use their powers urgently to deal with this issue. So I think the general comment does give a bit of a how-to guide on how to make the principle that deprivation of liberty is a measure of last resort and for the shortest possible period of time or appropriate period of time into a living reality. There is quite a lot also on the organization of the child justice system, the importance of data, of regular analysis, of revisiting child justice systems to make sure that they are constantly reformed to keep up with developments that we are learning about all the time. Also, I think in that regard, we would like to say that specialized work with children is very important, but training is hugely important. But I'm going to leave that because I know one of the other panelists is going to talk about that. So just to touch very briefly on the last 2 points, which are these two new things that are in the general comment. The one is on non-state armed groups and counterterrorism contexts. The United Nations has verified that there are many cases of children who've been recruited and used by these groups. A Security Council resolution in 2018 required states to establish procedures to rapidly hand over these children to relevant civilian child protection agencies or actors, and to treat them as far as possible as victims of violations of international law. Now, if in some instances they do end up being charged, that should be not in military courts, but in ordinary specialized child justice courts that will deal with them as child offenders according to the usual rules. This is very important, and the general comment flags the fact that any trials for these children must be the same, on the same basis as trials for other children, and must follow the procedures of Articles 37 and 40 of the Convention. Lastly, the issue of children who find themselves in customary law systems or traditional systems where they are dealt with through chiefs courts. The general comment recognizes that some of these systems do provide access to justice and might be an important thing to consider if one is doing law reform and systems reform in countries that have them, to consider whether they can be built in to a broader approach for dealing with child offenders. However, the committee also flags the fact that some of these types of processes are not child friendly, and it is crucially important that if they are going to be utilized, then they should be brought in line with the principles of the Convention on the Rights of the Child. So I will end there. I look forward to hearing the other panelists and to hear the questions from some of the participants later.
Thank you very much, Professor Skelton. It was very interesting, very important aspects you have highlighted from the general comments. I'm sure that there will be many questions and it will be a very good webinar. So now I'm going to introduce Judge Jorge Jiménez, who is a judge in Spain. He's also director of the Spanish Judicial School and director of the Ibero-American Network of Judicial Schools. It's a pleasure to have you with us. And thank you for joining this webinar, and you have the floor.
Thank you very much, Eduardo. Good afternoon, everyone. Good evening and good morning in all parts of the world. I would like to start by thanking the association for the invitation to participate in this webinar, and especially thanks to Eduardo, Melo, and your teams. Thank you very much. It's an honor for me to share this virtual training space with my important colleagues and with so many international colleagues by YouTube Live. And even more so in this special situation we are experiencing. This situation, I think, is an important opportunity to continue learning. After the very interesting exposition from Anne, it's my turn to speak about the judicial training in relation to General Comment number 24 on the right of the child in the juvenile justice system. I'm the director of Spanish Judicial School, and I have been organizing the training of Spanish judges for 9 years, initial and continuous training, and I am judge specialist in juvenile justice. In addition, I have a special relationship with Latin American judicial training through the Latin American Network of Judicial School. At this time, the first question that for me is important is when I am working on judicial training, the first aspect I would like to make clear here in this webinar is that training is a right. It's a right to all the judges, and at the same time, it's an obligation. Training gives legitimacy to the judicial function. The judges have the right to receive specialized, high quality and multidisciplinary training. I think it's an obligation to train. It's an obligation to provide such training. At the same time, the judge has an obligation to train, to attend training frequently, not only to acquire new knowledge or to learn about new legislation, about new law, about new jurisprudence, but also to review the practices, his practices, and retrain himself. This obligation to train, I think, is even more important in the area of the juvenile justice. In this area, in Spain, we have a law that this law requires an specialization for all the judges in juvenile justice. Judges working in juvenile justice must be specialized, have specific knowledge and special training. Such training is achieved not only by knowing the law, but by training soft skills that are very necessary to do their job. In this case, training is received on subjects other than law, for example, psychology, neuroscience, sociology, medicine, psychiatry, and leadership, among others. Skills and abilities are worked on Working with cases and performing simulations, it's necessary to have a good knowledge of all the measures that can be imposed in juvenile justice. It's very important, this topic, and it's also fundamental to work on attitudes. These attitudes are very important for all the judges, not only for judges that work in juvenile justice. The case method is used is the principal methodology in our training, and work is done through simulation and role play. Following this training, study visits are made to various institutions working in the field of juvenile justice. During these study visits, it's essential to learn about the work done by all these institutions and people working in juvenile justice. It's very important to know the prosecutors, know lawyers, educators, technical teams, police, detention centers, etc. This activity, this study visit, increase trust among those working in juvenile justice and helps to learn about all of points of view. It's very important, this methodology to get a good training. At this time, in the light of the general observation and the European regulation, it's necessary to unify the best practices in juvenile justice, and the most important topics in the field of training will be following these different topics that I am going to speak in this moment. It's important to make progress in enabling minors to understand and properly follow the criminal proceedings in which they are involved, to exercise their right to a fair trial, to prevent recidivism, and to promote their social reintegration. Perhaps this is the general aspect in our training. It's necessary to reflect on the presumption of innocence that should govern without the risk of the need for social intervention breaking it. Sometimes we can find situations in which the purpose of have a social intervention with children is to justify breaking the presumption of innocence. It's important the balance in these two topics in between the need of the social intervention and the principle of the presumption of innocence. Another aspect is necessary to go deeper into the identification of the best interest of the child, in the evaluation of the child and in the motivation of this best interest. The best interest of the child cannot be what I say, but it has to be identified and justified in our rating. Other topic important is training is needed on how the right to information of minor will be implemented in the process. For us, this is an important topic because it's important the effectiveness of this right. Knowing the person responsible for implementing the right at all times, the appropriate and precise language to be used, the specific form in which the information should be given, and the assistance of what means or person to do so. Information should be given on all the rights of the child, suspected or investigative from the outset, in a manner appropriate to her age and personal maturity, orally and in writing through documents and tests that are friendly, in accessible language and highly visible. It's very important, this topic. The child should be provided with information or explanation of the various stages of the process of the proceedings and the role of the various authorities involved in our proceeding. It's very important that the child know all of them. What is his or her function in the proceeding. The recognition of the right of every child to be heard and to have his or her opinion taken into account must be made concrete at every stage of the proceedings by establishing real and effective channel for this purpose. Listening must be absent from all pressures, express or implied, direct or indirect, in a friendly, not threatening, hostile, insensitive, or inappropriate environment, such as circumstantial demand considerable change in the space in the spaces and psychical elements where it takes place. Our core and our office is not the best place in this moment to give effectiveness to this right of every child. The opinion expressed by the minor in the exercise of his or her right to be heard should always be assessed, taking it into account in the relevant decision making, and it's important responding to it in language that is simple and appropriate to the minor. Sometimes you say that you taking into account the opinion of the minor, but this opinion is not reflected in the writing. It's only a supposition that you attend this opinion. Another important right to get training to have in account is the right to translation and interpretation in juvenile criminal proceedings. This right must be guaranteed, establishing how it will be carried out, how its effectiveness and quality will be monitored, and through which person it will be carried out. Any minor who doesn't speak or understand the language must be guaranteed the right to have an interpreter during police and judicial questioning at all hearings and court hearings during the proceedings. And in all communication with his or her lawyer is very important. You shall also have the right to have all essential documents of the proceeding translated into your language. It's important, this aspect. Here in Spain, sometimes the administration say that they don't have enough money to make this translation. It's easy to make a translation, an oral translation with the interpreter, but no, this translation of the essential documents, and it's important. Criteria and elements should be established to evaluate the quality of the translation and interpretation performed in order to ensure the effectiveness of the translation and the possible removal of the interpreter or translator without detriment to his or her right of defense. It's very important, this aspect, because in several audiences, in several trial, you can find that the interpreter, the children doesn't understand the interpreter, because the interpreter don't speak the language of the children. It's important to training and to guarantee this topic. The effectiveness of the right to defense must be improved by ensuring that they are effectively assisted through the procedure at first and second instance, and in the implementation of the measures. It's very important, the legal representation, the legal assistance for the children. It's important the specialization of these lawyers. It's necessary to establish some system to access to the quality of this defense throughout the procedure, and it's very important, specifically during the execution of the measures imposed with some system of supervision of this legal defense. In Spain, it's very usual that you can find this legal representation during the trial in first instance or in second instance, but during the moment of the execution of the measure, for me, is the most important moment for the children. Usually, you cannot find the lawyer. The lawyer is lost. Nobody know anything about this person. Is an aspect and topic very important. Another topic is clearly define how and when the individual assessment of the minor will be carried out, as well as the corresponding update throughout the procedure. It's very important, the right to individual assessment, because it's an important guarantee for the children. This individual assessment shall take into account, in particular, the personality and the maturity of the minor, his or her economic, social, and family background, as well as any specific vulnerability the minor may have. Also, it's important to receive the training, to get training about the right of the child to be accompanied by an appropriate adult, because sometimes the judges think that this is not a right to the children, it's only a right for the victim of the another offenses, no in juvenile justice, pardon. Some procedural steps will have to be established in order to assess the suitability of the adult and provide for procedures to challenge the possible declaration of unsuitability if the adult is not appropriate for these children. The last topic is important are the introduce the regulation of periodic ex officio control of precautionary measures involving the deprivation of liberty, and within what time frame this should be done by the judges. Here in Spain, when you decide a precautionary measure, the time for this measure is only for 6 months, but you can extend this measure another 3 months. It's important the control of officio, because it's important that this time was the minor time during the proceeding. And finally, another topic, I think is an important topic in this moment, is to know the benefits of restorative justice. Restorative justice in Spain in this moment is developing in our system, but in juvenile justice it's important the reality of restorative justice, because in juvenile justice you find the mediation like the more usual restorative justice. But in this moment, I think that it's important to introduce more restorative justice, including at the stage of the implementation of measures. In the stage of execution of the measure, it's important to offer the restorative justice. To conclude my presentation, I only say that I would like to emphasize the importance of juvenile justice for the state as a means of achieving the reintegration of those adolescents, of those children who, for different reasons, have come to the criminal justice system, preventing them from returning to it as adults in the future. Before that, the works like juvenile judge, I worked like adult judge, and sometimes I work in both places because I have to make audience and trials for my colleague in juvenile justice, and sometimes I found the same minor in one moment and 2 years after in the adult justice. No. I think it's very important for the state, the juvenile justice. It's very important to prevent to the children to go after to the general system of justice, the criminal justice. No, I think this is an important aspect that the democratic and social quality of a state is valued, because if you have an important system of juvenile justice, perhaps your criminal justice is going to be better, because you have less people in this system. No? And that is all. Thank you for your attention, and thank you.
Thank you very much, Jorge. It was very interesting and very comprehensive approach. We made a survey in our association about the specialized training provided to judges working in specialized courts, and for our surprise, in many developed countries there was no training for those judges. So it's very important to focus on this aspect, and it's an important issue for our association. So thank you very much for your presentation. And now I have the pleasure to introduce you to Honorable Justice Mohammed Imman, who was elevated as a judge of the Supreme Court of Bangladesh at the beginning of the High Court Division in 2001, and then the Appellate Division in February 2011. And he's chairman of the Child Rights Committee of the Supreme Court. Thank you very much for being with us, Imman, and you have the floor.
Thank you very much, Eduardo. Good evening, good morning, and good afternoon to all. And thank you for inviting me to say something about the child rights. My duty has been allocated as to discuss the implementation of the General Comments 24. Now, as I see it, there are two aspects to implementation. And the first is to ensure that the signatory states adopt measures for the implementations of the provision of the convention, as well as of the guidelines issued under the convention by the committee. CRC is now more than 30 years old, and yet a large number of states, signatory states, have not yet enacted legislation to implement the provisions of the CRC, let alone the provisions of any guidelines or the general comments. I feel that in this regard, the committee should be given more power to impose sanctions for non-compliance of the laws, because as I see it, signing a international instrument is like signing a contract. And whenever any state parties sign a contract, they are bound to comply. And Article 4 clearly says that the states' signatories must implement the provisions of the law by enacting laws in their domestic, in their countries, within their domestic laws. I must say that in May 2015, in a meeting in Phuket, in Thailand, I made the comment that perhaps we should have the committee having more teeth, and perhaps we should even go to the extent of having a court to decide whether or not state parties are in violation of the contract that they have signed, or in violation of their duties towards the children in implementing the provisions of the CRC and enforcing child rights. Everybody laughed, and I didn't mind, because obviously it's not something that's going to happen today or tomorrow, but I do believe that it probably happen in a few years' time. And I'm heartened to see that the committee is now, because of OP3, dealing with cases and applications. And there was a recent decision in Communication 30 of 2017, NR versus Paraguay. Now, that pleases me no end, because here it is seen that the committee is taking a positive step in trying to establish rights of children. Here, a child was trying to establish the right to visit her father in Argentina. Now, implementation so far as the CRC is concerned, there was the General Comment number 5 in 2003. And if I may just very quickly refer to one or two of those provisions, when the states ratify the convention, they take upon themselves obligation not only to implement it within their jurisdiction, but also to contribute through international cooperation to global implementation. Paragraph 8 says, wherever their economic circumstances, states are required to undertake all possible measures towards the realization of the rights of the child, paying special attention to the most disadvantaged groups. Paragraph 19, states parties need to ensure by all appropriate means that the provisions of the convention are given legal effect within their domestic legal systems. Now, where are we? That was in 2003. In 2007, there was General Comment 10, which said that many states parties still have a long way to go in achieving full compliance of CRC. That's after 17 years. And after 30 years, I believe we are still a long way to go to get implementation by 6 state signatories. Now, and has dealt at length with the provisions of General Comment number 24. And as it says, the aims are to have towards a holistic implementation of child justice system. Now, Anne has already mentioned the change of wording, juvenile justice to child justice system. And well, being English speaking and coming from a common law background, I think that's quite right, because juvenile, the word juvenile itself has unfortunately developed a negative connotation, which I think perhaps is best avoided. Now, there are many good things in this GC 24, General Comment 24, which really go towards establishing and ensuring the rights of children, particularly those in conflict with the law, referring to Article 37 and 40. But then, in addition to that, General Comment 24 actually does deal with something more than just just Articles 37 and 40. I will deal with that in just a moment. But first of all, if I can say that the real difference in the establishment of the child rights will lie in implementation, and that goes hand in hand with what Jorge said about training. Now, I have found that in this country, we train police officers, we train probation officers to deal with children in the way they should be dealing with children. And yet they change, and we have to go over the whole training all over again. Now, the most important thing, I think, with regard to child rights is not just the law. Many countries have law, other countries don't have the law. Maybe somehow we can get them to enact laws. But then the law itself is not going to be enough to ensure the rights of the children. It's the ideology, or maybe the philosophy behind the law, which then has to be determined by the stakeholders who are dealing with children day in and day out. I can give a very small example. When a magistrate came to my house, he talked very nicely, he knew all about the child rights, and as he was leaving, he said, "You know, sir, our children are so scheming in their behavior, they need to be locked up." Now, that is his mental attitude. Now, that attitude, that sort of attitude has to change. It can't change overnight, and it does need training, because we have to realize that the people who are dealing in the judiciary are from a different background to the people who come in front of them as accused of having done some criminal activity or offending or delinquent behavior. They come from the poverty-stricken backgrounds, especially in our countries, and therefore they are literally treated as something out of this world. They're not here, they're scum, they're bad. And therefore, they need to be treated in a different way. And equally, when children are being dealt with in the criminal justice system, again, there is a demeaning attitude of judges, lawyers, police, because they're children, because they're small. And I think this is where we have to make them understand that children, any child, a citizen of the country, is equally has the right to be treated properly and in accordance with the law. As has been mentioned already, the right to be treated as innocent until proven guilty. Now, that totally takes away our right to have them incarcerated or in detention, if you like, before the trial has ended and before they have been found to have committed that offense that they are alleged to have committed. Can we give them back the years that they spend in detention and custody? We cannot. And should we keep them there? I think the only time we should and we ever do keep them in custody is when they are a threat. Maybe that is the only consideration that we should keep in mind. Otherwise, children should not be kept in detention, because it is not neither for their own good, nor in fact for the good of society, because the children in the detention centers, they develop into gangs. They come out of there and they are more criminalized than they were before when they went in. Now, we have in our system the new law, which was enacted after a judgment that I delivered in 2006, but the law took a long time to come. It came in 2011. But we have tried to develop the scheme of letting children out, not taking children in, the last resort principle. If it is easier to send a child home with a warning saying, don't do it. Next time, be careful. That those few words tell the child what not to do. That may be sufficient to bring him to the right path. We have the scheme of diversion. Now, I'm sure all of you know that New Zealand boasts that their police deal with 75% of their cases through diversion at the police station. We are trying to do that also in Bangladesh. We are developing a child affairs police desk, child affairs police officers. They are being trained, and along with the probation officers, they will decide when a child should be sent out on diversion, if not released or discharged altogether. Now, diversion, what they do in diversion, again, guideline has been given in GC24. There are many things that can be done in diversion. Perhaps we don't know all of those. Maybe we need more training to deal with the ways of diverting. What do the children do when they're diverted? What do the probation officers need to do when a child is diverted and given to them to be dealt with? I think it's a question of training. It's a question of engaging children in some activity, some positive activity, so that they do not have time to go into their negative activities. Now, as I said before, if I may just make one observation with regard to certain points that have been raised in General Comment 24, which I think has actually left out something, and I do, with all respect, say to Anne, and this is something that we have managed to correct in our system, and that is that everyone talks about pre-trial detention, but nobody cares to deduct that period of detention that the child has spent in custody while the trial was going on. So if, for example, at this end of the day, he or she is sentenced to 5 years in custody in a development center, what about the 2 years or few months even that he or she has spent in custody during the trial period? My personal point of view, and I've insisted upon our judges to take that into account, is that those periods that they have spent, maybe periods, maybe long period, maybe short period even, but they have spent it in custody. In custody meaning away from their home, away from their loved ones, away from liberty. Their liberty has been taken away. What is the purpose of sentencing afterwards? It is curtailment of liberty. So if their liberty was taken away during the trial, then that should also be taken away. Now that in our country is quite simple. Although it is not in our law, I have worked it out in a different way. I've said to the judges, our criminal procedure code has a provision that any time spent in custody during the trial is to be deducted from the sentence. Although that is not in our child law, I've said that equally it will apply, because our child law says any provision not in the Children Act, so far as procedural law is concerned, then the criminal procedure code will apply. And therefore, the deduction of the pre-trial detention or custody will be there as well as for the adults as well as for the children. So that's something that I think perhaps should be added or maybe amended into the 24. Now, I just want to finish by going into the provision of elements of comprehensive child justice policy, section 4, capital A. Now, this is taking us away from Article 37 and Article 40. This is not anything to do with children who have committed an offense. This is to deal with children to prevent them from committing any offense, to prevent them from going into delinquency. Now, we've had in the past, we've had other instruments. For example, the Riyadh guidelines specifically deals with this situation. And the way I would suggest implementing, again, something that is in the back of my mind, I've talk to people about it. I'm trying to do something about it. And that is to get the children to be dealt with by their peers. Now, all children come from a community. And Riyadh guidelines, as well as General Comment 24 in Part 4A, deals with children to be how they should be dealt with in the community. Now, every child comes from a community. Immediate community is the parents, siblings. Then the next community is the neighbors. Then the greater community. Now, if all people get round to dealing with their own children, now see, whenever we have a child who has done very well, we boast our child, our neighbor's child. But then when a child has behaved badly, we like to avoid it. Now, this is where I think we have to tell the community, it's your child, deal with it. Now, the way I have a plan to deal with it, and I'm afraid I couldn't do it, put it into place because of COVID, is to go to the schools in the locality, have some children of an age band, let's say 14 to 18, who will be the peer leaders. They will have the duty to look around because they are also from that community. The children in that school or in the surrounding schools come from that very neighborhood. So they will look out for children who are about to fall to the wayside for whatever reason. For poverty, they can't afford the clothes, they don't go to school. They can't afford the school books and stationery, so they don't go to school. Or they don't have pocket money, so they're going to steal. Whenever that is noticed, then they will deal with the child at the very first instance. They will go to the local elders and say that this child is in need of protection, is in need of help. Can you do something about it? Now, in that way, I believe the children themselves will look after their other children, the children who are more vulnerable than they are. Now, I believe that in the long run, if you can catch the children who are about to fall off the track and bring them back onto the track, then we will certainly have less delinquency. And equally, whenever we tell children to behave, whenever we tell children to do this or do that or do the other thing, it's a lecture. And they don't like being lectured. But whenever somebody of their own age group tells them the same thing, that's advice. And it's easier to digest advice than to digest a lecture. So I believe that we should be taking the step forward to deal with the children in their own community. This is implementation at the grassroots level. I've talked about implementation at the state level of the law itself. I've talked about implementation of the law in the courtrooms. Yes, I should have dealt with a little bit more detail, but as to how the courts deal with children. Now, children are children. Now, you know Renate Winters, her very favorite phrase, children are children are children. I repeat that so often myself. And it is for us, the stakeholders, the judges, the lawyers, to deal with this situation and to think in the same way. How would we deal with our own children? You know, if I have time, I can just tell you one very small story about that very magistrate who said children should be locked up. I met him in another occasion with other judges. And I said, you judges, you wouldn't recognize a decent person, a good person, when you saw them in the street. And they all looked very puzzled. I said, well, you deal with criminals day in and day out, 24/7, because magistrates are on duty 24/7. And you don't recognize any good people because no good people come to you. But what would you do if your sister came running to you and said, brother, my son has been taken away by the police. He's a good boy. He didn't do anything wrong, but he was with some friends. They did something wrong. And along with those children, he has been taken away by the police. Now, judge, what will you do? You will run to the most powerful man you know, and you will beg and say, my nephew is a good boy, and I'll assure you that he will not do anything wrong again. He has not done anything wrong. He won't behave badly. Please help. Now, if you will say that for your kith and kin, who will say that for the child on the street? This is the attitude that we must change. The attitude of thinking that children who are badly behaved are bad. Think of how you would deal with your own child who is badly behaved or behaves badly occasionally. You would advise them. So we have to change the attitude of all the people. And again, that comes from training. It doesn't change overnight, but it will come from training. And we are trying to do that with all the judges, with all the lawyers, with all the prosecutors. Diversion can take place, police station, by the prosecution, by the judges. At any time, our law says at any time between the time of the arrest of the child till the delivery of judgment, the child can be sent on diversion. So I think that is a very important topic. But implementation of the law, there has to be, I feel, a law in place first. Because it's all very well having international instruments and being signatories and saying that we are dealing with child rights and we'll give the child all rights. But unless and until it is in black and white, unfortunately and sadly, they do not actually implement it. I think I shall stop there. Thank you.
Thank you very much, Imman. It was very interesting and very good points. We have 3 questions, and then I'll give you the floor, and just to finalize our webinar. And I think you may answer the question that you feel more into. So the questions are how or what can we respond to the idea of some prosecutors and judges that during this pandemic period think that children will be more protected from coronavirus if they are institutionalized? And the second question is how to implement diversion during this period when presential activities are suspended. And the third one, not more related to COVID, it is a nuisance issue in the moment. What measures or discussions can take place to change the actual common sense and understanding that children involved in drug dealing activities are victims of one of the worst forms of child labor and not a criminal activity? So who wants to begin? Okay, Imman.
I can begin. Since I finished, I can just continue from where I left. With so far as COVID is concerned, I think it's a fallacy to think that children are protected in the detention centers or development centers. Because number one, they are in a situation where they cannot easily be segregated. They will all be in the same mess. The other one is that other children will be brought in. Other offense will take place and other offenders will be brought in and they will bring in COVID with them. The third and more important aspect I would like to say is that children are always vulnerable and more vulnerable when they are accused of having committed some offense or in a system where they are being tried. Now here, I think they need protection from their nearest and dearest. Parents, they need to be near their siblings. So what we did during the COVID situation is that we tried to get as many children out of the system as possible, and especially those who were under trial. I personally feel that under trial means they are not yet guilty, and therefore they should not be there unless they are a threat to society. So have them out, have them in their homes, have them next to their parents. Their parents need them as much as they need their parents and siblings. And we had the good fortune of having UNICEF agree to transport the children in a proper way, meaning with maintaining distances and so on, to the parents. And also they provided a package so that the children would not be less fed, if you like, or would not be in a disadvantaged position. And more so, they had a package for the parents also. So I think all in all, we needed to get them out of the system. What was the last point that you raised, Eduardo, if you may kindly repeat? Your mic is on mute.
Yeah, it was about drug dealing and what measures or discussions can take place to change the common sense that it's the crime and not the victims.
I wanted to say specifically on this issue, there was an English professor, I believe from Essex University, who did some research in one of our suburban areas of the city. And she found, and the bottom line is that she found that children who are in the crime gangs or helping the crime gangs and taking part in the crime are in fact illicit labor. And she explained this by saying that these children are from broken family, dropouts from school. They have nowhere else to go other than the streets, and therefore they are easy targets for those bigger criminals who will use them to carry certain things, do certain criminal acts in order to make their end meet, give them a little bit of money. Also, I think it's important to realize that in a poverty-stricken area or country, region, the children will do whatever they are asked to do if they're in a desperate situation. For example, you have a child with parents who are both ill, not able to work, not able to earn a living. The child is a breadwinner. So the next person who says, here, take this packet and deliver this for me, and I'll give you 200 taka or whatever. Now, for that child, that 200 taka is important. And the packet, whatever it contains, is least important. It is just a job of work that he's doing, transporting and carrying something from here to there, getting some money in return. Now, is that child, if it gets caught in carrying firearms, for example, or drugs for that matter, is that child a criminal or a victim? My point of view is that the child is a victim. The victim of circumstances, victim of poverty. Equally, when a child is used, for example, by robbers to climb in through a small window where the robber can't go through. So the child is pushed in and he goes and opens the front door. Now, is the child a criminal? Again, I would say no. And I give you a small example. When I was training some judges in Armenia, the judge couldn't speak English, but used almost sign language. And he told us that a child, 15-year-old, smashed a supermarket window, a huge supermarket window, smashed it, ran inside, straight to the freeze room, got sausages, and ran out and got caught. And I said, did you prosecute him? Was he prosecuted? He said, no, he was hungry. I said, what about the broken glass? And he laughed and said, if he didn't break the glass, how would he get in? Now, there is the attitude of the judge who thinks that the child has committed something, yes, but is he a criminal? The answer is no. He's hungry. That is why he did something to get his stomach filled. I'll stop there.
Who's next? Do some of you, yes, please.
I can also have a go. So the first question was relating to this question of, what do we do about this attitude that children are safer where they are? In South Africa, our government also, when it first went into lockdown, said, let's leave the children in the youth centres, who are the children who are awaiting trial there. And our law requires children to come back to court every 2 weeks if they're in prison, and every 4 weeks if they're in any other form of deprivation of liberty. And so I immediately saw that we would be in breach of our own law if this were to continue. But the difficult thing about COVID is, it's a moving target. So right at the beginning, I thought that it might not be so unreasonable, but within 2 weeks, it becomes unreasonable, And so we pushed, and the Department of Justice then changed the law. And we started looking at a case-by-case consideration of every individual child. It's interesting, isn't it, that if it was adults we'd be talking about, nobody asked the question, well, we could release this adult because of overcrowding, but will he be safe at home? Nobody does that when they're talking about adults. And so with children, there is this kind of extra problem that it's like a hurdle we have to overcome, because of the fact that we also have to say it will be fine for the child to go home, it will be safe for the child to go home. And I think that does get overplayed sometimes. But I also think that there is some resonance to it, and what Justice Ali was saying brings some of it to the fore. In a situation in poor countries where households are struggling to feed children, one would want to see support being given to families if children are going to be brought back at this time when perhaps they rely on informal work, and the work is not available and there's no money and so on. So I don't think it can ever be a reason to keep a child in custody is because they might be hungry if they go home. Clearly, then you provide food if they're going to go home. But I do see that there is something in there that has to be, we as people fighting for children's rights need to think through what states have to do to make good on children's rights in these circumstances. And I think it's an ongoing process. As time goes on, we need to keep adjusting our minds and start, thinking about the next, which children next. If we've got the children awaiting trial out, what about the ones that are serving sentences? What can we do for them, and so on. Diversion, how do we do diversion when everyone's at home? Yes, I have seen that there is some work that's been done in America where the people have been designing online diversion programs. So kids have to sign in for a certain number of hours per day and do certain activities online. But that presupposes that they would have access to computers and so on, which many children wouldn't have. Another possibility, of course, is to delay it until such time as it can be done. This is a practical way of handling it. And then there might be some other more creative ways of doing things, like trying to work with families to say, what are you struggling with your child at home at the moment, and what program can we put in place that could maybe be supportive of that? So I think that there are creative ways that one could sort of design a specific diversion intervention for a particular child. On the last question about children involved in drugs and seeing them as victims, a few years back, maybe 10 years back, there was a lot of talk about children used by adults to commit crimes. It had an acronym, QBAC. And it was being pushed a lot by the ILO and various UN agencies and so on. And I must say, it seems to have gone rather quiet. One doesn't hear many people talking about it anymore. So I think it's important conversation, and we must start reviving that conversation. And we should push for laws to include provisions that say that where a child has clearly been used by an adult to commit crime, then it is the adult that must be charged and not the child. So I think that there are ways to start pushing governments to put this on the agenda and to actually have legal solutions to it.
Eduardo, I would like to share an experience in Spain. I agree with my colleague, but during the pandemic in Spain, all the judicial activity was paralyzed, and it was a problem for all the jurisdiction, and especially for the juvenile justice, for the juvenile jurisdiction, because all the measures that we executing during this time were paralyzed in this moment, and now is going to go to execution, but to execution. But in this moment, we have an important discussion between prosecutors and judges about the prescription of the minor crimes, because the prosecutors say that during this time, or the time is stopped and is not prescription, but the judges interpret that is the same. The children, the minor is not the worst condition of the adults, because in the adults the prescription is go, but why not in the juvenile justice? And in this moment, all the minor crimes are declaring prescription in all of them. And in these cases, it's impossible to execute a measure to have an intervention. But this is an effect important in this moment.
So thank you very much. We have no more questions. I want to thank the three of you and Skelton, Jorge Jiménez, and Imman for being with us and sharing your knowledge, your experience on this important subject. I also want to thank all attendees who are following us in our webinars and that were with us today, and remind you that we are going to organize webinars every month. We are going to we have 3 official languages in our association: English, Spanish, and French. The next one will be in Spanish, but all webinars have, as soon as they are finished, they are posted in our page, and they have subtitles provided in all languages, the automatic subtitles, but they are quite good and allow you to understand the content. And so I invite you, even if you don't speak Spanish or French, to visit our page afterwards and follow our subjects. So it was a pleasure to be with you, and I hope you continue safe during this challenging moment, and we can meet together in future. Thank you very much.
Thank you.
Thank you.